My husband was recently awarded primary physical custody of his 4 daughters, ages 9 to 17. Mom gets them on Friday, we pick them up on Sunday. Previously, this was our arrangement in reverse. We had them every weekend, school breaks, and 3 weeks in the summer. He had been paying $1,300 a month in child support, their phone bills, their car insurance, and half of all extracurriculars, medical bills, etc. Mom doesn't work. She hasn't worked in years. She lives with a boyfriend and gets government assistance. When custody was flipped, my husband's child support ceased, but we were not awarded any child support at all from her because she claimed she has medical issues that prevent her from working. All she had was a hysterectomy recently, which she will recover from and be fine. In their original divorce, she was working and was given the ability to claim 2 of the girls on taxes. My question is, why is it okay for her to be a deadbeat parent in the eyes of the court and not have to contribute financially to the raising of her own children? And is there any way to get the tax benefit at least reversed? We owe taxes every year. Okay, so let's go with the easy one first. Your last question. Can we be given all of the tax credits for the kids? Yes, you should have been. Part of your modification of child support should have given you all of the tax exemptions because they are awarded in proportion to income. Next, let's look at the Arizona Child Support Guidelines. It tells us when income should not be attributed and when it should be attributed. There are only a few reasons why income should not be attributed to a parent. So those are incarceration, physical or mentally disabled parent, a parent engaged in reasonable career or occupational training, unusual emotional or physical needs of children common to the parties, or a parent is a caretaker of a young child common to the parties and the cost of childcare is prohibitive. None of those apply in your particular case. You didn't say that mom was disabled. If the court made a finding that she was disabled because of her medical issues, then it would be okay for them to not attribute income, but that might be something that you could consider appealing because the child support guidelines don't say medical issues. They say only if a parent is physically or mentally disabled should they not be made to contribute to the needs of the children. The only other thing that a court could do is they could find a deviation and deviate down if they found that mom couldn't contribute, but mom should be able to contribute. And it sounds like what happened was the judge said dad can afford it and therefore mom should be off the hook. And I agree with you. That's really not in line with the law or the underlying purpose of child support or the assumptions that both parents should support their children. So that's my thoughts. You might consider talking to a lawyer. You also want to take a look and see if you've already been given those child support exemptions.